the program. Good morning, Salon. They continue as inside this edition of the program today. Radio Democracy. They can look at the different measures the Modi Salon Judiciary don't announce this BNTM as a whole against the fight on drug. But again, this measure them where they introduce this BNTM, another set of legal body get concerned when the lawyers society when that's what they can look at today. We can talk about this particular issue. I welcome two gentlemen with we will get another studio, and I start with Francis Murray, PRO for the Salon Judiciary. Good morning and welcome to the program.
Good morning and thanks for having me.
Also get Claude Bami Davis, PRO for Lawyer Society. Good morning and welcome to the program.
Good morning, Santi. Good morning, Good morning, society.
So they bring you in, Francis Murray from the Salon Judiciary PRO. So before we talk about the new measures or directive announced, take we listen and view them through waiting on the happen at the Salon Judiciary, especially for enhance and improve access to justice.
Okay. Famula no say we now the only independent arbiter of justice. We the 1991 Constitution gave a mandate for preside over cases both civil and criminal, and for administer justice to the people of this country. And whilst we carry out this constitutional mandate, we minded for DOAM independently, impartially, with integrity, fairness, and whatever it takes for ensure say we got them up and running. And so one of the most beautiful things we happened recently in the Sierra Leone Judiciary in the appointment of the Honorable Chief Justice Kabaka Manda, we don't rise through the ranks of the judiciary, and he come with zeal and zest for ensure say this most powerful arm of government way for complement the activities of both the executive and the legislature up and running effectively. So a lot of things will happen on just little below 1 year now we assume office. But the most striking one a novelty in a salon from where they established the Judiciary of Sierra Leone for the first time. The Court of Appeal moved now the provinces where not to think we for sweep under the carpet. For the first time, like we have mentioned in the wisdom of the Honorable Chief Justice, Court of Appeal not for only the seat na Freetown. And Sierra Leone is not just Freetown. The other provincial areas put together, Freetown not even near the population within the provinces put together. And there are lawyers practicing there. So anytime they get an appeal, past the court of an appeal matter, past in Camp Freetown for put the appeal through. Imagine this, the pain, the delays, transportation fares, and therefore pay for witnesses. That is a burden to litigant. The Honorable Chief Justice said no. Part of court to me administration is increasing access to justice. Say, well, let me take the court to the people. And so he assigned a panel of 3 justices for move to McKinney first, for start and roll out the first Court of Appeal sitting in the provinces, which has been welcomed by lawyers across the country, both local and internationally. Why appeal is important? Because every process within the judiciary, every legal process forget an appeal system. Cases from the High Court can don't be completed. Lawyers and get 1 or 2 reasons for cry foul, say no, I don't agree with this. They need for appeal. They need for get the appeals for work faster, not to pass for common. Imagine somebody get they na Kabbalah where if you say in client don't be wrongfully convicted, a lawyer need for come Freetown file case. So now he says go to McKinney, which is the closest distance from Kabbalah, and have your cases reviewed within the shortest possible time. So that is welcoming. Also, most recently, for the first time, we'll open a court now mile 91. We don't see the rate at which cases they pop up around our axis day. And the Honorable Chief Justice being a proactive individual, being a young person who want for get the ends of justice working. So well, let's go have a magistrate court in mile 91 for sinking that gap will be there between Waterloo with a big jurisdiction, a big judicial area for cover, and mile 91. So we get a magistrate there now. And also we recently opened another new branch structure na Kono. And recently also we complement the fight against sexual offenses. We opened another SP court na McKinney, which is welcoming because before now if you get an SP case pass you canton, if you didn't have McKinney, we don't open one at Bo, we don't open one at Kailang. So this one at McKinney also is welcoming for the North. For CC, we expedite cases effective justice delivery, effective administration of justice is key for the Honorable Chief Justice. Much more importantly, they don't prioritize professional development. We know say our judges are trained, they are qualified, but in this changing space where we do in the legal field, where everything changes on a daily basis, there's need for get you judges, your manpower up to speed with within the happen. So a not shut down in doors to professional development for judges. There's been training, especially on the new Criminal Procedure Act, for roll them out speedily and expeditiously without any encumbrance on my part. We don't get 2 trainings. Now there are other additional efforts for if you roll out sentencing guidelines and what have you for ensure say the wheels of justice they ride on smoothly. So, I will go on and on and on and on for
with all entail you don't say for improve the justice sector again concerning about transparency and on being fair to the public, especially with set of people we unakino say belong other side. The view from the public this so the justice system, as you emphasize, is transparent. It's not that transparent as you say.
No, well, we're not going to control the views of the public. But what we do as an institution is to go with the law, what comes before us. And in doing so, we take into consideration all laws were applicable to that particular offense where the person they appear before we for. So we know the handpick as to who is before the court. We don't have politicians, we don't have any minister, we don't have person of stature or character. When you come before us, if it's a criminal case, you are an accused person. Well, now a defendant. If now a civil matter, of course, you are either a respondent or a plaintiff, and we don't treat everybody equally.
Okay.
So for say we're not transparent. No, everything happens in broad daylight. Our judgments are read in an open court. Judges go to court every day. Whatever happens, even with the very issue they are for, with the issue out. Okay. The media is working. We put out press releases as when necessary for CCA. We draw the public to be in abreast with what they do.
Okay. When the Honorable Chief Justice will take up office, one measure we introduce now the issue of speedy trial. So CCA expedite cases them we don't deal in a court for long.
Certainly.
How that don't impact the justice sector?
Well, in the first place, like I tell you what I start, he has a track record from a magistrate, we sit almost everywhere across this country, rise through the rank of a high court judge, court of appeal, and before he assumed the office of the Chief Justice, he knows the issue, so not to stranger. When he came in, the first thing he set the basis, the foundation. He said, well, now the bail is a much more contending issue. We don't spill into every other administration. Previous Chief Justice say, well, as an experienced bencher, let me issue out 1 or 2 measures for ensure say the speed at which we preside on cases. He issue out several directions on bail. And now he has made it clear that bail is the default position, except where admitting that person to bail would have 1 or 2 serious impact on societal peace and tranquility. So across the country, there's been now this memo. If I issue out a memo on the time where magistrates for go in a court, not later than 9 o'clock, every magistrate across the country should be sitting after 9, and we get an official tell the off. And that measure that cut across the entire divide in Judiciary, both the High Court, the Court of Appeal. Now you see cases being handled with speed and efficiency. Because he say we complement that directive in the interest of justice.
Francis, I asked this question because quite recently there is a report where the Human Rights Commission of Salon Pool now they tied to human rights behind bars, and from them findings it shows get about 5,468 inmates and 2,125 at the main correctional center.
Okay.
We should say there is this issue of overcrowding still they exist now the prison
okay. Overcrowding, not only the judiciary is responsible.
But now get a major role for playing.
Of course, and when we play in that major role, and sometimes when cases come before us, especially for defendants now, you appear before you make your case for bail, the judge or the magistrate take into consideration all relevant laws for either admit or not, go act accordingly. But sometimes even when for magistrates, where before now we do criminal investigations, now we get committal proceedings. When the magistrates don't do in committal proceedings and commit the matter in the High Court for trial, if the matter fall within that purview for the trial at the High Court for serious offenses, felonies, when it go, it is not only left with us, family need to understand this process. If they go to law officers department, usually the remittance to law officers department, law officers department, they go review that file there. We not get any, we not been getting any bearing on we after we don't commit it to the High Court. The law officers, they go review and prefer the appropriate charges before they send the file back council. Before now, we not get any space limit as to when they do that one day. And so we not go pile pressure on them, say this file we don't send out to now and remit them back to. So this is synergy between the we and other stakeholders.
Apart from that, part of the findings are that one, the issue of adjournment, the plenty adjournment of cases them. Two, most of the inmates not don't appear in a court. And three, the one that we don't appear in a court, sometimes when they appear in a court, either the judge or magistrate not can be available.
No, that is an issue of the past. You know, correct. We have a very strict Chief Justice. We hands-on and know what they do. When he gives out a directive to judicial staff, be it a magistrate or a judge, he follows that to the letter. When he issue out the directive on bail, me and a few others, they part of the team will be the monitor for ensure say the courts are up and running. If they do, we don't do at the media. If they do on the spot check to magistrate court, they don't do on a Ross Road, they don't do on a Pademba. For say nobody not flout that directive in the interest of justice, not to fall heavily on the benches, no, but for ensure that justice is running smoothly. The accused persons also get right to speed and fair trial. Now that make it put them measures here. Okay. For the issue of prolonged adjournment, sometimes it's not going that's for the well, thankfully, in fact, now that the new Criminal Procedure Act don't come, with a streamline criminal trials for say this particular offense will be tried within this social number of days. So brilliant lawyers now go say no. The fact say this case don't date before this court for this long, it's a grant for appeal. So that issue is now being sorted out by reason of this welcoming Criminal Procedure Act with just streamline court proceedings. So unnecessary adjournment, he has made it quite clear to every judicial officer saying if a defendant or whoever appears before you and the state will bring and come 1 or 2 times not show up, you can discharge. Not me say no, come back. Now when you acquit and discharge means the matter ends there until any other thing happens. But you can discharge. Let the defendant go first. Okay. When the state sees they can come back. So there's speed at which things are happening. Okay,
continue for the route. We name now Francis More in a PRO to Salon Judiciary. We will give general update on the different things and reform where it's on the happen at the Salon Judiciary. They come over to Claude Bamideris, PRO Lawyers Society. Before we begin look at the main issue, you don't hear from the PRO2 from the Salon Judiciary. We don't give updates, but the things where the leadership of the Salon Judiciary don't they do for improve and enhance improvement. As lawyers, we can always get concerned in line with issues we relate to the judiciary and how they execute the mandate. From what he is saying in all of this, you think say that they reflect or more need for be done?
Okay, thank you very much. Yes, we welcome the reforms where the judiciary will always take, not to from now, even from other past chief justices. We don't see certain reforms, and if that the help we practice, and particularly for enhanced justice and the independence and fair trial, in the courts, then we welcome that, right? And we always set out now that we not for they do things as a judiciary or officers of the court we they in contravention with the stated laws. And in fact now that make we come into this issue not all about the reforms taking courts to the provinces, access to justice. We welcome all of that because that enhances our practice and it gives the judiciary a different face, right? But we cannot be seen doing things with the against the provisions of statutes. And any time when anything that they happen, we get duty, the Lawyer Society, because we make a commitment to the people of Sierra Leone, say we go stand as guarantors and protectors for the rule of law, good governance and democracy. And so anytime when we get the opportunities, then they will come. We'll set the record straight, say we not go allow posterity for judge we on the wrong end. We will speak about it. We have no issues with individuals. We have issues with we have concerns on issues and principles. So now I don't know if you permit me.
No,
for
we can
clar-
look at the recent practice or directive will
Yeah.
come up from the Salon Judiciary. Continue for the with we name now Claude Bami Davis in the PRO for Lawyers Society. Program Good Morning Salon, they continue from them break they will come over to a studio guest them as we get to gentlemen they will we don't talk about thing they don't happen at the Salon Judiciary. Now inside the program we can look at the new measure them this BNTM where the Salon Judiciary announced outside and state the role on how they would handle issue we get for do with drug, and we see the same first them state something they would call direct practice. Well, for can't talk with some of the entire where the Salon Judiciary would do as the role, and they bring in Francis More for the interest of we listen at them. You can state some of the things that where the Salon Judiciary outline as memorandum or best practice where they call the role towards the fight against the issue of drug.
Okay, so before I can accept to you, we as a development partner see the issue of drugs. In fact, the reason for the memorandum first is that the issue of drugs now a national emergency, and we don't see across the country we're losing our youthful population to drugs. We have a number of evidence, pictorial evidence across the country where youth them with for drive the workforce for tomorrow, they perish, they succumb to the force of drugs. And people really dealing in drugs here because it is rewarding, they are determined for continue. And if this is the case, an institution mandated by law for preside over cases we can't before we need for step up. And so in the wisdom of the Honorable Chief Justice, as a father also, we know one for let any other combined picking go through waiting, we youth then they go through so today. Issue the practice directive. Now why then practice directive here? They are issued in situations of emergency. It is an inherent right given to all chief justices. It's not novelty. All chief justices will occupy that seat, don't move appropriately when it is informed by data say what we are faced with as a nation, like national threat to our very existence. It was the same for COVID-19. It was the same for rape and sexual related offenses in 2019 when they didn't hide. Thankfully, if you watch the rate at which rape or sexual related offenses were committed between 2019 to 2022 and compare how they can, now we can have a whole criminal session will not get any SP matter. So that means practice directions even in the past have worked exponentially. So this one also not to an exception. So in the height of them drugs here, the past say, let me show how to practice directive. There are two ways for you to practice directive. Two statutory instruments where Lawyer Bamino say exhausting, demanding, time consuming way for go lay paper, draft, send to Attorney General's office, draft, send and back, will go months. And we no one for be blamed tomorrow say we wanted to follow procedure and then we watch with youthful population they perish, which gives the Honorable Chief Justice the alternative for issue of then directives here. We know they anywhere outside in powers. So part of what he is saying is that all offenses were related to drugs now for be concluded at the High Court. Okay. And also he say by reason of the rate at which we they feel and we they see the damning effect of drugs across the country, the magistrate courts not for grant bail. It not say bail should not be granted. The magistrate court not for grant bail. And secondly, it not say the right of the accused persons to speed the trial key. And he say across the country, priority now therefore be given to all drug-related cases. So when they come with it, treat them with urgency and priority across the courts. So they can stand down any other criminal matter, then call a drug-related matter for give speed at which they will for try them. And then next, he say not only that for try them with speed and for let them go fast, every other court, not the seats of Saturdays, except for the Nasit court. He said, but now it mandates judges or magistrates for step outside the official hours, for begin sit on Saturdays if it is convenient. If you see say the cases are overwhelming, mind you, they never pay them for Saturdays. The cases are overwhelming as we know they are now. Court can sit on Saturdays. So now part of the measures for join the national fight for fed drugs and for cut that supply chain where they hit into the fabric of we
We will look at the measures them one by one. When you talk of practice direction, what does that mean for the layman out there when you talk of practice direction?
All right. practice direction now, as the head of the judiciary, where the law mandate for deal with cases. 9, now the administrative head of the judiciary. He owes direct responsibility for say the judiciary up and running effectively and they give justice to everybody. So the law give him, as the sitting chief justice, the inherent power for give practice directions. And then practice directions are in the interest of justice, fairness, and expeditious justice delivery. That not in any way they question the authority for issuing practice directives. Like I say, all chief justices I tell you about the COVID-19, I tell you about the 2019 rape pandemic, sexual related offenses, and all practice directives have always been issued across the globe, sir.
According to the right of the chief justice and you get that power, but under which circumstances it can issue the practice direction?
Okay, I stated earlier, I say now when there are issues of emergency, when we feel there's an issue where we all deal with collectively as a nation, as a people, collectively for combat, then practice directives are issued. When COVID-19 came, not to be one person in effect, it needed a concerted effort of all key stakeholders within the criminal justice system for joint effort against COVID-19. When rape came, we see how people go out to demonstrate, especially after the Khadija incident, across the streets. And the judiciary then also issued a practice directive for ensure say we curtail, we clamp down on the one that we feel say we young girls and women them, we are just commodities we can buy at your pleasure. So it has always been working, not to say. So we consider also now in this time now drugs as a national emergency. We obviously every well-meaning Sierra Leonean, with the Chief Justice now one of them well-meaning Sierra Leoneans can say, well, let me say move in, let's as an institution. There's much we can do for fighting the fight against this heinous practice we don't intend we image internationally.
Now the contribution from the judiciary in the fight against drug and drug-related issues, then make on put measures also in place. But concerns that don't come up from different quarters with regard to measures also, as according to some people that the measures also get some kind of human rights implications. One, the one get for do the issue of custodial sentences. Two, already is the directive given by the Chief Justice, they determine the outcome of the trial.
Okay, so when except one for lose sight of the grave nature of how drugs don't dent we image both nationally and internationally, and most importantly we youthful population, we if then old folks here now then are positions of trust fade out, you not get responsible youth for rely on, for fall back on, for continue the dream and visions of Sierra Leoneans, it get to be very challenging. Now then people also way they deal in this trade of drugs, they are highly coordinated. Now for instance, the issue of bail, we don't be able bail. If a drug lord we don't make so much in drugs, come before the court, and then you get money for continue for fund that enterprise deal, and then in lawyer just come and apply for bail, you get them. You have done no good to society. Mind you, part of we motto, we mission statement say now for administer justice in this country, for promote national peace, security and development. And we see say the way drugs they go in this country, they threaten with peace. We are not safe as a nation. So then directives here very much they try for tighten up the space for let people we want for venture into that act, want for cut the supply chain, because if you detain the drug lord, you don't cut off your enterprise, you terminate the chains of distribution. But if you let them back into the society, they use the same finance for fund the thing they happen, and so it not go stop. So this is a concerted fight. This has to be intensified. This is broad daylight. There's broad daylight evidence, overwhelming evidence of how Kush detrimental to we existence as a people. So we welcome them, concerns them, but this is what works best. It was the same for rape. Now we will open a criminal session. We hardly hear an issue of sexual penetration or rape, because there are stiffer measures put in place, and that is the very reason why laws are in fact promulgated. And the court they work for data, we think we could convict for data future occurrence. So if you can convict somebody, we don't come into the country with let's say a bag full of cocaine, you get 15 or 20 years. What have you done behind bars? What have you done?
Okay, Francis.
In the interest of peace and national security, we motto they say, now that make with the factory job.
Okay, Francis Mori, PRO to Salon Judiciary, continue for do it we as a just don't talk about the 6 directives so commodities being from the Salon Judiciary. Outside and believe say this na the role for effect against the issue of the drugs. Over to you, Claude Bami Davis, PRO lawyers, Lawyer Society. We still not get concerned about these 6 directives we come out from the Salon Judiciary.
Yes, thank you very much. We want to make this clear again, say, we statement, in we press statement, say, we welcome any idea we get for doing robust measures for curtail the drug effect in a salon. But the key thing we, I think, say, me brother, the miss that, we have said those measures should not come into conflict with the already established laws. That is our position. And where they refer to the sexual offenses get an act, and the measure would have been taken not fall foul with the provisions of the Sexual Offences Act. Now, in we concern, we say, if you say you get right for make practice directions, we know say practice directions are derived from statute. I make this example again yesterday. The High Court rules, where we they use Order 62, Rule 2, the Chief Justice. It is stated therein, say the Chief Justice go make laws. The Chief Justice may give practice directions generally for carrying out any rule in these rules, that is the High Court rules. So he say it gets right for give directions for carry out any rule in that rule, and not say out of the rule.
So this is out of the rule?
Yes, okay. We're saying this is out of the rule. Because now, let us take the practice direction. For, number 1, we consider that it say all charges under the National Drug Control Act shall be concluded in the High Court. Now, you're saying them offenses them we can be summarily tried in the magistrate court, not for be concluded. Now if we go on committal proceedings and be concluded in the High Court, that is like repealing the law by memo or by practice direction. It is in contravention of the act already.
Okay.
Right. Then number 2. No, let me just summarize. Let me say.
No, with the camp for a break, we'll come back. You will still continue. Okay. Claude Bami Davis, my name, PRO Lawyer Society. Inside the program now, at time for go for a break. The program now, Good Morning Salon, and they come to you from the Society for Radio Democracy 98.1 FM. We still get Claude Bami Davis, who is now the Public Relations Officer for Lawyers Society. Before we go for that break, you will make a point on the concerns that we want to get. You can continue for that side.
Yes, thank you very much, Adeyemi. So, I mean, they say, when you take the practice directions one by one, we lay out the issues that we get, some concern about. I say, number 1, the practice direction say all charges under the National Drugs Control Act shall be concluded in the High Court. This clearly don't contravene procedures, because even in the National Drugs Control Act, you get offenses them way go be summarily tried in the magistrate court, instituted, heard, determined in the magistrate court, summary trial. But by this practice direction of the Chief Justice, they don't say all charges, not giving consideration to those that can be summarily tried. They say for be concluded in the High Court. So basically, that they mean say there has to be committal proceeding now for take that matter to High Court. Before you go to the next point, how cases are normally don't they move na the courts? Well, you get matters them way. By the old Criminal Procedure Act, they call them PI, preliminary investigation. Then it will be instituted in the magistrate court for conduct preliminary investigation, and then commit to High Court. Now we get committal proceedings by the new CPA. So you start them from the magistrate court, then you send them to the High Court. There are certain offenses for that when they're indictable offenses. So right? But you get one them way. the magistrate court can start and conclude. For example, we will not them amicus case them. You no need for Kango High Court. So you get a minor matters them we will call misdemeanor, where the magistrate court can try and determine. So what thing that they say is, when in say by the practice direction, say all the charges under the National Drugs Control Act for go to High Court, then you don't alter the proceedings by the very provision of the Criminal Procedure Act of 2024, we will just adopt. Number two, the issue of bail. It say, yes, we know the practice direction number 2 say bail not for be granted only in compliance with section 76 subsection 1 of the Criminal Procedure Act, where that provision they say offenses when a murder and treason, magistrate courts no get right for grant bail unless the High Court, and there is a reason for that. Now by this practice direction of the Chief Justice, in say then drugs related offense they not for grant them bail na magistrate court unless you go to the High Court. So we're concerned that you don't equate or liken drugs related offenses, even though you get the minor ones as well. You don't equate them to heinous offenses like the murder and treason. How would you just equate that? If you get reason for say, okay, them offense they are, if na robust action we want take, table it to the Attorney General, make a present them for Parliament for amend the Drugs Act or the CPA, right? Because in fact this CPA, now this is not the interesting thing. This now the National Drugs Act Control Act done they in existence from 2008. 2008. Then we just adopt the new Criminal Procedure Act in September 16th or so. This year, just September. If and drugs we don't begin able kush. So if you wanted to be proactive and you wanted to take robust action on this issue, then make a recommendation, a position paper to the Attorney General for make it table that, okay, make this, let we amend or make we pass a regulation. We're saying due processes ought to be followed. We're not against the robust action. A regulation, so that then go put drugs related offenses na section 76 1 of the Criminal Procedure Act, so that they no go grant bail na magistrate court but rather the High Court. That is what we're saying. Wait, please, let's just done. Then we not get problems with direction 3 and 4. We talk about for seats. In fact, now then we say now the actual issues then that for practice direction, how you go enhance the rules or the laws stated, not to for contravene them. So when you say make them meet, make court the seats on Saturdays, well and good, we have no problems with that. That is good, right? And speedy trial, that is good. It is not in contravention with any law. Now when you come to number 5 of the action, the direction, it says custodial sentence is a must. Now the act, National Drug Control Act, get in penalties them for various offenses. Some then they win a 5 years or fine of 5 million or 20 million or 5,000 millions or 20,000 millions. The act from section 7 up to section 17 of the National Drugs Act, it states waiting for be the punishment, either imprisonment or fine or both. Now you can by your practice direction, you say it is a must that's a custodial sentence. So you don't contravene the act will give provision for either custodial sentence or fine for some of the offenses. And then number 6, the last one. This is very, very ironical, in fact. You say any person found guilty under subsection under section 7A to C, where they talk about the manufacturing, transport, cultivation of drugs or whatever, it say for be imprisoned for 30 years. When you go to section 7 of the National Drugs Control Act of 2008, that section makes provision for imprisonment, for life imprisonment. So it's even funny now. Life imprisonment, you make them 30 years. Which one is serious? Not only life imprisonment. So in your quest for robust action, you even they reduce the sentence, because life imprisonment is more serious than a fixed term of 30 years.
Okay, but me quick one before we go for the next material. And all of them concerns here, so we don't really say Lawyer Society get with regard the new directive where the Chief Justice don't give. One go ask say if the Chief Justice not get the power for do so.
Yes, when we follow strictly the provisions of the law. As we note in the press statement, we say the authority for make practice direction get for be derived from the law.
But the Chief Justice get the power?
No. It gets power if the act says so. But the act not say so. This National Drug Control Act not say that. Now, I don't make reference to the High Court rules. Make reference. In this one, we can do this practice direction. There is nothing. In fact, it gives the authority to the Minister of Internal Affairs. And there are sections in this act where it won't give power to other people them where the act contemplates a big provision. Section 25 of the National Drugs Control Act. It tells you say the act gives powers to the Attorney General by statutory instrument to make certain regulations. Section 25 of the National Drugs Control Act of 2008, it gives power to the Attorney General for make certain regulations, authorizing designated staff of the agency to exercise their powers conferred on police officers or by the Police Act of 1964,
Okay.
the pharmacy. So it gives that one. Then you come to the issue of application for warranty only. For warrant, you say an application for warrant for search and anything, it gives the power to the executive director or a police officer not below the rank of Assistant Inspector General of Police of the court.
Okay.
Then it comes to section 47. The DPP again task. He said the DPP is tasked with responsibility to apply to the court for disposal of part of the substance of any drug-related substance. So the act contemplates the one the way it gives authority.
Okay.
There is no mention of the Chief Justice.
Continue for the with Claude Bami Davis na in name in the PRO for Lawyer Society, but they talk about in concern we didn't get from the 6 directives so commodities being taken from the Salon Judiciary.
The program Good Morning Salon, the continue will come to we other studio guest winner Francis Moray, Public Relations Officer for the Salon Judiciary. You don't listen to Bami from Lawyer Society on the concerns them we then get. One, get for do whether the Chief Justice gets right under the National Drug Law Control Act of 2008, and also the issue of custodian sentences, bail, and other one them. Waiting on a makeup of them concerns as we they don't raise.
Okay, I want to start first for say the issue of the practice directive we mentioned of 2019, say you know contravene any provision of the act then is misplaced, because the practice directive frankly been robbed off the magistrate court the chance for do PI or sexual related offenses up to this date they go high court. But as at the time the practice directive was issued, no magistrate could not be the do PI. Before they were doing PI, it was the same practice directive issued by the Honorable Chief Justice then, so that has been clarified. Then, for the practice directive, it is issued in the form of guidelines where they dictate how the court should be operated. Now, all of the acts with the reference, none not say any other rule made by the Honorable Chief Justice is inactive. All of them are silent on that inherent power of the Chief Justice for make practice directive. We now a guideline on how the court for conduct itself in the interest of justice. None of them not say any other rule for the conduct of cases are rendered null and void. It not say so. None of the acts not say so.
So the Drug Law Control Act give the power to the Chief Justice for make the rules here?
Read and say, in fact, the National Drug Law Act we reference say, if let's go back to the High Court rules. The one we read say, the act mandate the Honorable Chief Justice for make rules generally. Rules generally, in also with specific respect to an act. So for the conduct of criminal cases generally, the High Court rules mandate the Chief Justice for make practice directive. No.
Allow one, please.
Now he read it here. The High Court rule says the Chief Justice is mandated to make, where appropriate, general rules. And also with respect to any act under criminal trials. That yes, you read that I take a note. I take note of them. And then, this, if we are going by the letter of the law, the same act we don't make everywhere down, define court in the preliminary sections, section 1 of the 2008 Drugs Control Act, define court as high court. There's no mention of the magistrate court where they say no court, no they.
So, in all of waiting, Claude Bami state, is it that facts not depend on the concern the way they
well,
is?
now they submit so. The interpretation section of this act, the 2008 act, define court as high court. So any conviction now, in fact, that is a catch we lawyers they now go begin for pursue. Any conviction by how this act, the letter of this act, the spirit of this act say, any conviction now by reason of how they define court as a high court and the magistrate court is a nullity. A brilliant lawyer can go before the high court and appeal. Say the letter of this act no include the magistrate court as a court. So it's a high court. Defines court as high court. That is one. Please respond to the other points where it is. So the high court rules now general rules where, like we say, the chief justice get the mandate for make general rules applicable to high court to criminal trials. Now it also talk about all charges, and he say no for Kai again from the magistrate court. That was the same with rape. With rape, in fact, rape, the magistrate court was exempt from conducting PI, as it were called then. So all that happened at the time now, that all rape and sexual related offenses be going at the high court directly. Here we are saying you can go for PI, but no magistrate is allowed to grant bail. We have seen instances where if you so want to appeal, or you so want to rally around the court to admit your client to bail, you can go to the high court. Nothing not stop the high court, a lawyer who has a client in the magistrate court, from approaching the high court whereby this practice directive give the mandate to any high court judge for grant bail. That is there's also this issue of bail, what have you, not a novelty. I don't know why would they make high or heavy, would they make them too big. International tribunals like the War Crimes Tribunal now Yugoslavia, all the convicts will be there before the court, before well-accused persons, they were all denied bail. In fact, they were presumed guilty even before the trial started. They not even entertained bail. The same be happen as Salon. In we special court trial. All the accused persons, for this court, Hinganoma, Charles Taylor, all of them were denied bail.
So what about the custodial?
Did that rob them of a right? No. Now to the custodial sentence we make reference to. Now, a bit laughable, because when you come to other serious offenses, the life imprisonment we make mention of. Now, until the Correctional Services Act is amended, when a convict is sentenced to life imprisonment, not to life imprisonment to the serve, you serve barely below 20 years imprisonment, not to life imprisonment. So what is wrong if at the height of this national emergency, the Honorable Chief Justice give a directive say all offenses in this regard should go for 30 years? It's not alarming.
Okay, Francis.
So for life imprisonment by the Correctional Services Act until it is amended, you don't go for life imprisonment like and a day die. You do little below 20 years.
Okay.
Not as it is stated.
Francis,
so these issues are not from we'll not just pull them anywhere.
Continue for the with us inside the program. We need for take some message, and we'll come back to you later, Claude Bami Davis. Inside the program now with Facebook page, we take some message, and this one from Mark 10 and New England will say, Bami, the new directions by the Chief Justice could also undermine the fundamental legal protections for an accused individual. Where then is the security of the law for one who is falsely accused?
This one from David Joseph Ali say, can the PRO2 tell Sierra Leoneans how they have contributed to reducing adjournment and right to bail of civil matters in the courts?
From David Joseph Ali, they say, as the Lawyer Society engaged the Office of the Chief Justice of these issues raised by them? If yes, what has been the response from him?
This one from Lancelot Thomas said, the CJ has the right to introduce new directions in the judiciary, but it must be within the ambit of the existing law. With this new directive, it is at variance with Parliament.
This one from Lancelot Thomas said, the CJ has the right to introduce new direction in the judiciary, but it must be within the ambit of the existing law. With this new direction, it is at variance with Parliament.
This one from Mactense Bame, these new directions by the Chief Justice could also undermine fundamental legal protections for accused individuals, where then is the security of the law for one who is falsely accused. From Macten.
From David Aliu, they say, can the PRO to tell Sierra Leoneans how they have contributed to reducing adjournment and right to bail of civil matters in the courts?
This one from David Joseph Ali say, as the Lawyer Society engage the Office of the Chief Justice of these issues raised by them? If yes, what has been the response from him?
From Supercaps Food in our Facebook page, saying all of this explanation, the layman cannot understand the complexity of the law. So you need to do consistent public engagement to people to get better understanding.
This one from Acten say, bail is not merely a procedural convenience, it is a safeguard that balances the state's interest in public safety against an accused person's liberty and the presumption of innocence. Removing or unduly restricting that safeguard risks turning pre-trial detention into a de facto punishment.
The last one I take from a Facebook page is posting, they say the Salon Judiciary need to be consistent in informing the public as long as the law has to deal with the public. From their message, and they come over to a studio guest. I will start with you, Claude Bami Davis, PRO Lawyer Society.
Yes, thank you very much. So before I respond to the concerns from the texters, make I just clear within me friend talk about me allusion to Order 62. Rule 2 of the High Court rules, right? If forget say that order they talk about the provisions of the High Court rules, not to general laws. So it says the Chief Justice may give practice directions generally for carrying out any rule in these rules, that is in the High Court rules, not generally in rules all over the place. Say generally in these rules, for the carrying out of rules in these rules, which are the High Court rules. So make the reference, they say it means the High Court. In fact, the High Court rules now for civil proceedings. This na criminal law we talk about. So I was just making reference, say the practice, that the authority to the Chief Justice for issue practice direction definitely could be derived from the statute. So for the High Court rules, again, right, for make provisions as to how you conduct the provisions of the High Court rule, directions for the provision of the High Court rules. In the National Drugs Control Act, there is none. In fact, Section 91, 9 say the minister, the Section 91 of the National Drugs Control Act, it said the minister, when are the Minister of Internal Affairs, can make regulations by statutory instrument, that is, you have to make reference to Parliament. Okay. So even the minister. Now, we are saying the guide way they talk, we are not against practice direction. I think we don't make that clear. But enough fall out of the provisions of the law. You cannot make practice directions where they contravene the law. It will be done insofar as the provisions of the rules or the act are concerned. So, insofar as that are concerned, so you cannot do otherwise. Now, when you don't say 30 years, so right, first of all, you don't interfere with judicial the judges' independence. When I core values of the judges' code and under the Bangalore principles, you don't tell judge they now say or magistrate say na 30 years or all thing for be custodial. When the act say you get additional additional orders. He said like Section 12 of the Act. So I just try for lay. Okay, so Section 12 say he said if you try for convict person under Section 8 of the National Drugs Act, the court has powers to make additional penalty prescribed for that offense. Okay. Make order. So if he gets additional penalty, like say, okay, in fine, you now don't say custodial sentence. So you already don't interfere with the judicial independence, so the judicial independence. But in all of this, they come out from Lawyer Society. Which one are the acts? So is it that the acts for the Chief Justice reverse and decisions here? So? Oh yes. The end bit of we press statement that with the column for review this practice direction and make it pull then things them we contravene the provisions of the already established laws.
All six of the directives. All six of the directives.
No. I don't know before. We don't have the problem with speedy trial. There is no contravention to any law for the speedy trial and sitting on Saturdays.
Okay.
No, but 1, 2, 5, and 6.
What if then
they contravene?
Then what if the Chief Justice or the judiciary as a whole no adhere to waiting at the actual waiting could be the next step for Lawyer Society?
We can't state that now, but we will take necessary action. There are ways to do it. We have ways to do it. We have several ways to do it legally.
Claude Bami Davis, continue for you to quickly over to you, Francis More. Una you don't hear the concern in anyone go consider the concern of the Lawyer Society, the Salon Judiciary.
Not only when we feel say the Honorable Chief Justice don't act arbitrarily or outside of his powers.
And this time he is not.
He has not. He's never been. Everything he's done is according to the law. And this practice directive, like I start, now inherent power where the law give him for issue practice directive. Quickly on the points the way Mr. Bami is. All like it failed for response to the fact say none of the acts not make mention say a practice directive issued by the Chief Justice should not be entertained in the conduct of trials. They no say so. He read them. The minister, yes, the minister does not know how court proceedings go. So should the minister make rules as to how cases should thrive in court? No, it will be misplaced. It is the place of the Chief Justice, who is the head of the judiciary. Should anything go wrong, now everything they fall back.
So in all of this,
so the drafters of that will say
we didn't get the authority.
What they don't make and clear say any practice directive other than this stated in the act should not be entertained. They don't know.
Francis,
no.
So between Una two gentlemen from the legal field, who is giving the actual and correct information to the public now? This
is a form of public education. It is left to the public to judge. So, but far and above every argument that has been made so far, the Honorable Chief Justice, being the head of the judiciary, is the first gentleman who should uphold every law that applies to Sierra Leone, and he has been committed to doing just that. We consider then side comments here as mere distractions, because we're determined. Like I said, the fight against drugs and the impact we get on we na a national issue. I don't reference we motto as an institution we say of our Minister of Justice for promote peace, security, and development. This very rate at which drugs they go, one, there will be, it will stifle development. Our image, investors will be scared away from coming here. Security, our youthful population stands threatened their livelihood.
So how you know say they measure your own directives here from the Salon Judiciary at the best, because you describe them as the best way we start? How you know that? Because we know say by experience, a memo by way of a practice directive don't work best as against the statutory provision where they for make paper go away, they delay all of the bureaucratic arrangements, you go for a ride, the processes. By experience, all Chief Justices don't execute this inherent power we then get for ensure speed, accuracy, and efficiency in judicial proceedings. So this is not to out of the blues move with the Honorable Chief Justice do. It is part of what he does for ensuring that the conduct of every matter before the court is in the interest of justice. So Sierra Leone has for say somebody sent message on how we don't fight for adjournment on civil cases. In fact, the facts say now the burden on lawyers to file appeal cases from the province to Freetown don't be cut down. Is a plus to we, because we're taking out the Court of Appeal to them. We mean say the cases in the provinces now should be handled expeditiously. Okay. After Makini, we can Kenima. Okay. And also, the Court of Appeal now is moving with speed. Civil cases can take time because of the arguments and the cases where they can be. So every judge, every panel of the Court of Appeal is determined for sweep the cases before them. In conclusion, what the public for believe and accept from your own side?
Okay, I want for the public no say. We, as the only independent arbiter of justice, know that institution in this country where the law give rights for trial cases, both civil and criminal, and for administer justice to Salon people. So one for crave and the indulgence that the leadership of the judiciary is committed for stick to the law and for ensure say justice is served. I know the angle lawyers they come out, because you know when these drug laws then they go, you say you have to get bail, then the child money. No, we say I want to get bail.
to you,
okay,
please.
we don't pinch us more. Say they will charge dollars for it. Say, well, I'll grant you bail. But how do you send back a drug lord into the community? Where it will still go and facilitate the process.
Okay,
so
for
lawyers
instance.
are GT because that lump sum will go in their pocket. Now we don't cut and double.
It's a serious exception to that.
But that's
Serious
the
exception.
The program
That
they
is the truth.
conclude now. Over to you, Bami. Waiting from your side, waiting the public for believe and accept at this time.
Okay.
Because also they give different interpretation.
Okay, the public, they make their judgment. I don't state the provisions of the law. What I would say is that the Chief Justice, or by extension the Judiciary, is tasked with the responsibility to implement laws and not to re-legislate them. Not to forgo make your own law. Parliament, there are three arms of government. The legislative arm now gets the responsibility for make laws. The practice directions for fall in consistency with the provisions of any law, not against it. So the Chief Justice has no authority to re-legislate without any regulation. So I go let fumble them with the words of Barack Obama for make them go believe, say, as for our common defense, we reject as false the choice between our safety and our ideals. Our founding fathers, faced with the perils that we can scarcely imagine, drafted a charter to assure the rule of law and the rights of man. A charter expanded by the blood of generations. Now, these ideals still light the world, and we will not give them up for expediency's sake. You know, the trade law because you want for take robust action.
Okay, well, that's now Claude Bami Davis, PRO Lawyer Society, where we talk about the concern we then get from the Salon Judiciary outside the state 6 directives we then go work on addressing the issue of drugs. Also, we get Francis Mori, PRO to Salon Judiciary, where we talk about why then directives there and based on waiting where the Chief Justice decide for take them directives here, and according to them this now as the your role for help tackle the issue of drug. Plenty thank you to all to be with guest inside this edition of the program Good Morning Salon.